So good afternoon, Hank, Carolina, everyone else that's out there. Appreciate you taking the time to join us this afternoon to discuss wills and trusts, understanding what your estate plan options are. So we're going to go through this. Of course, I'm Cameron White, and I'm an estate planning attorney in Windermere. And we do all types of estate planning, from the simple to the complex. We also do probate and trust administration, also involving small business owners and real estate. So what the purpose of this webinar is simply to clarify the basics of what wills and trusts are. So if you, throughout the presentation, if you happen to have a question come up, just throw it into the chat and Gabriella will address those questions at the end. Okay. So that's me. Okay. So who needs an estate plan? Well, pretty much everyone. Everyone needs an estate plan because with an estate plan, you have a big say in everything that happens to you. And that could be to yourself, your loved ones, your assets, when either A, you're incapacitated, or after you pass away. What an estate plan does is it simply sets up a structure that's intended to minimize conflicts. It's intended to honor your wishes and allows for a smooth transition of your assets to your loved ones and those you want to have your assets, be it investments, cash donations, personal items. So a common question we get, or statement we get when we first meet someone, is, I want a will. And our question to them is, why do you want a will? I don't know, because I saw it on the internet and I read about it. Here's where we start working. And that's to understand the differences between what's a will and what's a trust, because they're both very important components of an estate plan, and they can help you achieve your goal. However, they serve completely different purposes. So, like I said, someone will come in and say, I want a will, or I want a trust. I don't know how they work, but I've heard this and I've read about it. They both have, once again, distinct characteristics. We also want to make sure that we understand what your personal circumstances are, which one would suit you better than the other. We have a tendency to, if we determine that a trust is better for you, then what we do is we complement the trust with a will. And how do we know all of this? Well, it's because we sit and we speak with you. We peel back layers of the onion to get to what the underlying concerns are. So that's another component of an estate plan. So what is a will? Well, a will, it states, how do you want your assets to be distributed when you pass away? Who do you want to handle the distribution of your assets when you pass away? Here's the thing, a will only takes effect when you pass away. So you can make changes to the will throughout your lifetime, and it means absolutely nothing until you pass away. It does go through probate. And here's the difference with no estate plan, with an estate plan. If it's a will that you have, you're making your wishes known to the world. This is how I want my assets distributed. It can include how you wish to be treated after death, such as, do you want to be buried or cremated? I want so-and-so to manage my affairs for me when I pass away. So there is probate that's involved. What is probate? Well, probate is where your will has to be validated by a court. It can be it in Florida, it is public. It can be costly, and it can be lengthy, depending upon the circumstances. What's the limitation of having a will? It does not allow for any ongoing management of your of your assets, or any control of the distribution of your assets while you're alive. Okay, that's the limitation of a will. It only becomes effective once you pass away. Why would someone want to choose a will? Well, it's simple. It's less expensive than a trust agreement. It's good for simple estates. It's, such as those with few assets. If you just have a home and a car and maybe a checking account or banking, very limited banking accounts, you have very straightforward wishes. If your primary goal is to simply distribute assets and without continuing control or management of those assets, such as, if you have minor kids, or you have adult children that are not financially responsible or have credit problems or this and that, maybe a will is not the right way to go. We don't know. Now, what's a trust? Well, a trust is a legal agreement that holds and manages assets for beneficiaries. Here's the difference between a will and a trust. A trust is effective immediately when you sign the trust. So it's immediate, it's effective during your lifetime, and it provides the flexibility that one may be looking for asset management. So you have various types of trusts that are available. They start out with either a revocable trust, which means you have control over those assets. You have control over the management and disbursement of those assets while you're alive. Or you have the irrevocable trust, which means you no longer have control over those assets. Okay. Everyone back? Sorry about that. We're technological issue there.
We're hearing you.
Good. Thank you very much. Once again, I really appreciate your patience. So let's talk about what a trust is again. A trust is basically a legal agreement where you're asking, meaning a grantor, which is you're making the trust, you're asking someone to hold and manage your assets for the beneficiaries. You can be a beneficiary, your kids, your spouse, family members, friends. And a trust is almost like a living probate. And what that means is it's active during your lifetime, and it provides that flexibility to manage your assets when you're incapacitated. So it gives you like an extra layer of protection. Now, like I mentioned earlier, there are two different types of trusts. There's a revocable trust, which means you can make changes to the trust at any time, and an irrevocable trust. And what that is it's a trust where you do not have access over those assets. There's pros and cons for each type of trust. Where a revocable trust, like I said, you can make changes whenever you want. You maintain control over those assets. The other, irrevocable, you do not have access or control over those assets. Now, why would someone want to choose a trust? Well, number one, if the asset, this is key. If the asset is owned by the trust, that asset avoids probate. It saves time and money, and the distribution is private, which means it's not recorded in the public record like a will. Also, by avoiding probate, it's an instantaneous transfer. of the asset. There is privacy, like I said, because it's not recorded in the public record. There are conditional distributions, or you can make, excuse me, let me clarify that. You can make conditional distributions of assets that are owned by a trust. What's an example of this? It could be maybe you have an investment account, and when you pass away, you don't want the beneficiary, who could be 18 years old, 25 years old, inheriting $100,000 and blowing that money, maybe on crypto. Maybe they blow it who knows where and how. You can control that distribution and say, okay, I'm going to give you either X dollars or a percentage when you're 18 or you're 25 or whatever age. And you can set it up in steps, meaning age intervals. You can make it conditional. Are they a law-abiding citizen? Did they graduate college? Do they have a career? Things of that nature. So you're not left without any choices on the distribution of your assets. Also, a trust can provide asset protection for the beneficiaries of those assets. What do I mean by that? And that means a creditor of the beneficiary cannot come and take their inheritance. Give you an example. Let's say that they have a judgment against them for $100,000. Well, here comes John Morgan or Dan Newland or one of the other personal injury attorneys come knocking on the door and say, Mr. and Miss Beneficiary, I have a judgment against you for $100,000. Well, you confidently, the beneficiary can say, fine, I don't have $100,000, but you've got this inheritance that creditor cannot touch, period. So it provides that type of protection for your creditors as well. Can you have a will and a trust together? Yes, plain and simple. What we do here is, let's say you have a trust. It's important to make sure that your assets, if you have a trust, your assets are owned by the trust, or the trust is named as a beneficiary. Without it, it would go into a will where the trust is named as the beneficiary. Okay? And that's what we call a pour over will. That asset moves into the will that's poured over into the trust. For any asset that is not owned by the trust. Now you're thinking, what about my house? What about my cars? What about my retirement accounts? Well, cars you don't have to worry about, okay? Because those under the Florida probate code are exempt from probate, and those can be transferred. Investment accounts, those have to be owned. Those can be owned by a trust. Retirement accounts, they have to be owned by a person. They cannot be owned by a trust. But the trust is your main vehicle to avoid probate. That's it. Okay. A will, that's just probate. And your assets would go through there. But once again, if we have a trust, we name the trust as the beneficiary under your will. So what happens if you don't even have an estate plan? That's fine. Okay. If you don't have an estate plan and you pass away with assets, well, a judge is now in charge of distributing your assets and putting someone in charge of the distribution of your assets. And that person could be someone you don't even like, or someone you don't get along with, or someone you haven't spoken to in many, many years. Well, under Florida law, you've inherited their estate plan. You've inherited their asset distribution methods. And no matter what anyone says, your beneficiaries have no say-so in how those assets are distributed. Meanwhile, a beneficiary can say, well, why are they inheriting 30%? They haven't spoken to mom, dad, brother, or sister in 30 years. But why do they get it? Well, it's because the law says they get a portion of the estate. Well, I don't want my brother, my sister, my aunt, my uncle to manage my assets or distribute my assets when I pass away. Well, guess what? Florida law says this is the way it is, and the judge has no authority to move away from what the law says. Assets can end up in different places. Let's say you have $100,000 that you want to give to a charity. You've told people about it. So what? If you don't have a will, you don't have a trust, the charity's not getting it. Not happening. Because once again, the judge has to go through Florida law on the distribution of your assets. Let's go back to the $100,000 example. Let's say your children are 18, 19 years old, 17 years old. If they're minors, that money goes to a guardian who you may not, it may go to the biological parent who you may have divorced and you haven't spoken to. It can go, if they're 18, 19 years old, that money goes 100% to the beneficiary. So do you want that to happen for your grandchildren, your children? Are your children financially responsible? Do they have creditor issues? Are they going to lose this inheritance? So that's why it's important to consider having an estate plan in place. Medical concerns. If you can't make decisions for yourself, who's going to make those decisions for you? Well, just because you're married does not entitle your spouse to make those decisions for you. So if you're incapacitated, either the court will nominate a third-party guardian for you, or we get it set up in your estate plan. It could be in a trust. It could be a declaration of pre-need guardian. It could be in a power of attorney, but it's in writing and it's available. The estate could also face increased taxes because the beneficiaries are the last ones to receive a distribution. Meaning, we don't, right now, the federal estate tax is $12 million. And you say, wait a minute, my assets are nowhere near 12 million. That's fine. That's today. But one of the unknown variables that we discuss when we meet is we don't know what your assets will be when you pass away. We don't know the value of your assets when you pass away. We don't know what the federal estate tax will be when you pass away. And we don't know your age when you pass away. So without knowing any of that, is your estate plan properly set up to address those concerns? If you say, well, I had my estate plan done 10 to 15 years ago. Well, once again, do you have those same assets? What was the tax planning that went into those documents at that time? Don't know. Haven't looked at them in 10 to 15 years. Something we need to consider. So, how do we make the right decision for you? Well, let's take a look at your family situation. Is it a blended family? Is it not a blended family? Do you have multiple properties, investments? Do you have specific ways that you want to have your assets distributed when you pass away? You care that the distributions are made public, or that anyone can search the records and annoy the daylights out of your personal representative to maybe sell the house, do an estate sale, buy your assets? Do you want your creditors to know? Don't know. We also take a look at and see, basically it comes down, what are your estate planning goals? What are we looking to accomplish with your estate plan? Are there charities that you want to leave money to? Once again, these are things that we discuss and that we uncover through the process, the estate planning process. And one very important thing I want to keep in mind, everyone keep in mind rather, is an estate plan is not a one-time event. An estate plan, we don't know if it's going to work until you pass away. So just because you sign it, that's not the end. Okay. So that's basically the difference between a will and a trust. Does anyone have any questions?
So if you're, let's say your beneficiaries, in this case, I have two children and a husband, if they're on the accounts, i.e. my investment accounts, my bank accounts, um, will it still go to probate?
That's a great question. The answer is no.
Okay, so they have to be on the house and all the accounts. If
Well,
yeah, I don't.
the house, there is protection for the house in Florida. Your homestead property is protected under the homestead laws, which means it's available to the surviving spouse and minor children. Okay.
Okay. Okay, yeah, because we have two properties at the moment. So it
Okay.
wouldn't cover the second one.
Well, we do have something available for that second property that can help it avoid probate.
Okay. And then another thing, I am a disabled vet and I get the tax benefit for the homes. So I don't pay any property taxes. That's going to start this year. Um, if my home is owned by the trust, will I still be given that privilege or would it be taken away because I no longer own the house per se?
Well, the answer is yes. It is protected. And the answer is no. The homestead protection does not go away. Number one, we recommend that the trust not own your homestead property.
Okay.
Okay. But we create a different type of deed that names someone or a trust as the beneficiary. So when the surviving spouse passes away and there are no minor children, it can transfer to a trust or it can transfer to an individual or class of individuals. Okay.
Okay.
So we make sure, and that way it avoids probate. Because if your goal is to avoid probate, we look at every opportunity that there is to avoid probate.
Yeah, I just recently learned a couple years ago what probate is, and I have a friend, their father passed away all of a sudden. He was named on one of the homes here in Florida, but then he had property in New York and Texas and Jamaica, and it all went to probate, and they're still kind of fighting that, and it's been 3 years.
Yeah. I mean,
So,
you've heard, you can just Google. There's, let me back up. If you don't have an estate plan, who are some people who never had an estate plan? Well, Prince, and he died over 5 years ago, and they're still probating his estate. Aretha, Aretha Franklin in Michigan, James Brown in Georgia just finished probating his estate 20 years later after he passed away.
wow.
Okay. Um, some people that I'm sure many people have heard of that do have an estate plan, but that was never updated. How about Marilyn Monroe? Guess who's receiving her benefits? It is actually her manager's family.
Oh, wow.
And this was before she married Joe DiMaggio back in the 50s or Arthur Miller. Uh,
Wow.
who else had an estate plan? Is anyone familiar with Jim Morrison of the Doors?
Yep.
Hmm.
Well, guess who's getting his estate? His girlfriend's family, because his girlfriend passed away several months after he did. In his
Wow.
will, that was written 5 to 6 years before he passed, he named his girlfriend.
Hmm.
And now they're receiving, his girlfriend's family is receiving all royalties from the divorce that he is entitled to.
Wow.
So that's why it's important every couple of years, maybe, minimum, to let's just sit down and look at your estate plan. Has anything changed? Do you still have those assets? Did you acquire any new assets? So it's important. Did Jim Morrison intend for his girlfriend's family to receive that? Have no idea. Did Marilyn Monroe intend to have that happen? We don't know. So
Wow.
anything else,
So,
guys?
Cameron, you mentioned that retirement accounts cannot be owned by the trust. Upon my death, can they be poured over into a trust?
What happened? Yes, it would. Did we name the trust as the beneficiary under those
No,
retirement?
I don't have a trust at all. I was just curious about that.
Oh yeah, absolutely.
Right now, all my investment accounts and retirement accounts simply have beneficiaries upon death.
Okay. Then those assets, those investment accounts and retirement accounts would avoid probate and go directly to those beneficiaries.
Okay. Yeah, I'm not worried. I wasn't worried about it. I was just curious. I did not realize that trusts could not own retirement accounts.
Yes, that's correct. Okay. Well, if there are no other questions, once again, thank you very much, everyone, for attending. We apologize for the little technological glitch there with Zoom. But if you have any other questions, please do not hesitate to reach out. Give us a call, send us an email. There's our information there. Yeah, we'd love to sit down and help as many people as we can.